This is Colin O'Keefe for LXBN TV. We are back from Legal Tech New York, and today's topic of conversation is the National Labor Relations Board's second report on social media. They released one back in August of last year, I believe. And though this is coming a little bit later, the report was released on January 25th. This is a topic I wanted to be sure to cover. So bringing in to discuss this today is Robin Shea, attorney at Constangy, Brooks & Smith, and author on the excellent Employment and Labor Insider, one of my favorite employment law publications on our network. First off, Robin, the NLRB, as I mentioned, issued a report, back in August, discussing employee activity online and that type of thing. Do you know what the impetus was for the second report and what differences we may see?
Yes, I think the main reason for the new report is that they had about 14 more new cases, and so whether you agree with the NLRB's position or not, I think they are to be commended for keeping us up to date on their position on these issues. It's making it a lot easier for lawyers to advise employers about what they can do. And then I think the other reason for the report was, according to Leif Solomon, acting general counsel, this continues to be a hot topic for a lot of people, including lawyers, human resources professionals, the media, and the general public.
Mm-hmm. And I've seen a lot of criticism from employment law bloggers about this report. Guys like John Hyman, Jason Shan, Dan Schwartz have all been critical of this, especially surrounding all the types of things that are forbidden from social media policies and what employers can govern online. What do employers need to be especially careful of, in putting in their social media policies? And are there any forbidden acts that stand out to you as being, particularly unreasonable?
Wow, good question. I do agree with John and Dan and everybody who has been somewhat critical of the NLRB's position on these. At the same time, I think what the NLRB is trying to do is take kind of a First Amendment approach and look at, will this social media policy have a chilling effect on employees exercising their Section 7 rights, which is to discuss terms and conditions of employment and to take concerted action. What the January decisions particularly really emphasized that the NLRB takes a dim view of vague and overbroad social media policies, and where you say, we want you to be appropriate in your communications on Facebook and Twitter and other social media, or we don't want you to make disparaging remarks about the company. The NLRB is taking the position that provisions like that in the policy are just flat out violative of the Act. Fortunately, in this January document that they put out, they did have two policies that actually passed the NLRB's high standards. And the first one actually specifically said you may not use social media in a way that would violate our no harassment policy. And the actual policy specified all the types of harassment that was prohibited under their no harassment policy. The NLRB said that was okay. And then the other employer's policy that passed was a drugstore chain, and I like this one even more. I think this one is even more helpful in advising employers, because what the policy said was, go ahead, use social media, but don't disclose or use our confidential and proprietary information, which I think they had a perfect right to say. Don't disclose, and this was a drugstore again, don't disclose employees or customers' protected health information on social media. Yeah. Obvious. And don't disclose any information that the corporation has embargoed or isn't ready to release to the public yet. That's getting ready to await publication. And so that was okay. So I think if you take the no harassment social media policy and put it together with this one that the drugstore chain used, you can probably put together a pretty decent social media policy that the NLRB might actually be happy with.
Yeah, yeah. And lastly, kind of where do we go from here? We have, a pretty strict set of rules from the NLRB. We have a general populace, and especially workplaces, that are adopting social media more and more on a daily basis. And then lastly, we have a lot of employers out there with existing social media policies that may violate the NLRB's rules on this type of thing. So where's this going, and is it going to all come to a head in the near future?
I think it will come to a head, although it may be a while, just because the wheels of justice always turn slowly, but especially with respect to labor cases, because you have to go through an administrative law judge proceeding, followed by NLRB proceeding, followed by appeal to the U.S. Courts of Appeal. So those things can just drag on forever. And by the time we get any definitive word on what an employer can do, it may be years from now. What I would recommend employers do right now is carefully review their current social media policies, even if they had a good lawyer help them with it when they adopted it, because until August of this past year, we didn't have a whole lot of guidance on what an employer could do. And now that we have this NLRB guidance, even if you had a good lawyer helping you put your policy together, it may not pass under the NLRB's new standards. Another caution is some employers or some attorneys, including me, have recommended that employers put in a disclaimer saying that nothing in this policy is intended to interfere with an employee's right to discuss terms and conditions of employment, blah, blah, blah. Mm-hmm. The NLRB said in this January publication that will not save a policy that doesn't pass muster. Yeah. And so I would still include that in the policy, but the fact that you have that in the policy isn't going to be enough to save you if the rest of your policy is too broad or too vague. All that having been said, I would say to employers, don't flip out about it too much, because if the only thing you've done wrong is have an overbroad policy or an overly vague policy, the remedy is to change your policy or scrap the policy and post an NLRB notice in the workplace. There's no monetary liability associated with it unless you fired somebody for violating the policy. So it's not the end of the world, I don't think, even though I don't agree with the NLRB's position on some of these things either. The last point is related to the second point, which is because there's no monetary liability unless you fire or demote an employee for violating your policy, be sure you do consult with qualified labor counsel before taking that type of action against an employee for violating a social media policy. This stuff is really a mess, and even if you try to follow the NLRB's guidelines, you can imagine with 50 friends talking on Facebook about something that the employer did, you're probably going to have protected discussion in there mixed in with unprotected discussion, and it's going to be tough sorting it all out. So, definitely don't take action against an employee without getting some good legal advice first.
Yeah, you don't want to be one of those many companies that we've already seen where, it's part of one of the many Facebook firings cases, because people will cover it and your name's going to get out there and it's going to be, here's another list of somebody else who fired somebody because of Facebook. And even though it's something that if they said that type of thing in the workplace, they may be out of there, but it's just with the NLRB, with these types of things, they've been very strict. So it's going to be very interesting to watch. Well, once again, that's Robin Shea of Constangy, Brooks & Smith, and author of the excellent Employment and Labor Insider. For more on social media and employment law, where those intersect, it's a very hot topic right now. Be sure to check out employmentandlaborinsider.com and, of course, lxbn.lexblog.com. Thank you, Robin.
Thank you.